You are standing in a cotton field in Louisiana just after dawn in 1896. The air is thick and wet. The rails of the East Louisiana Railroad cut through the center of town, silver and humming faintly in the heat. You watch as a man in a light summer suit approaches the station platform. His name is Homer Plessy. He is 34 years old. His shoes are polished, his ticket is paid for, and in less than an hour he will be arrested for the crime of sitting down. But you don't know that yet. Right now, all you know is that the world is divided, not by law alone, but by custom, by signage, by the quiet violence of separation. There are water fountains labeled by race, schools that will not teach certain children, benches, bathrooms, waiting rooms, all split down an invisible line that everyone can see. And no one has yet answered the question, does the Constitution allow this? You are standing in Philadelphia in the summer of 1787. The windows are open in the Pennsylvania State House, but the air inside is stifling. 55 men sit in rows, debating the structure of a new government. They argue over representation, taxation, the powers of states. Some own enslaved people, some do not. The word slavery will not appear in the document they are drafting, but its presence fills every corner of the room. James Madison is speaking. His voice is soft, but his words are sharp. He knows that the union they are building is fragile. He knows that compromises are being made that will haunt the republic. But he also knows that without compromise, there will be no republic at all. And so the Constitution is written. It contains no promise that all people will be treated the same. It does not say that the law must be blind to race or class or origin. It says that certain rights exist, speech, assembly, arms, trial, but it does not say that everyone may access them equally. The Bill of Rights is added 2 years later. The Fifth Amendment says that no person shall be deprived of life, liberty, or property without due process of law. But it does not say what due process means. It does not say whether a state may treat people differently based on who they are. For 75 years, this silence holds. You are standing now in a different kind of room. It is 1857. The Supreme Court chamber in Washington is dim and lined with dark wood. Chief Justice Roger Taney is reading aloud. His voice is slow, deliberate. The case is Dred Scott versus Sanford, and the question is whether an enslaved man who has traveled to free territory may sue for his freedom. Taney's answer is no. He says that black people, whether enslaved or free, are not citizens, that they have no rights which the white man is bound to respect, that the Constitution was not written for them. You stand in the gallery and listen. The air feels heavy. The law, in this moment, is not neutral. It does not pretend to be. It divides people into categories, citizen and non-citizen, person and property, and it does so openly, without shame. This is what the law looks like before equal protection. You are standing in the ruins of the South in 1868. The war has ended. 4 million people have been freed from bondage. The question now is what freedom means. Does it mean the right to vote, to own land, to attend school, to testify in court, to walk down a street without being stopped? The Congress is debating the 14th Amendment. It is being written in response to the Black Codes, laws passed by Southern states to control the newly freed population. Laws that say a black person cannot own certain property, cannot gather in groups, cannot speak against a white employer. laws that say freedom has conditions. The amendment is meant to end this. Section 1 contains 3 clauses. The first says that all persons born in the United States are citizens. The second says that no state shall abridge the privileges or immunities of citizens. The third says that no state shall deprive any person of life, liberty, or property without due process of law. And then, at the end, the 4th clause, nor deny to any person within its jurisdiction the equal protection of the laws. 14 words. You stand in the gallery of the House chamber and hear them read aloud for the first time. They sound simple, almost plain, but the men debating them know what they mean. They mean that the law cannot create 2 classes of people, that a state cannot pass one law for white citizens and another for black citizens. That protection, legal, physical, civil, must be the same for all. This is the promise. But promises, you will learn, are not the same as practice. You are standing in New Orleans, 5 years after the amendment is ratified. The city smells of blood and brine. The slaughterhouses line the riverbank, and the waste runs into the water that people drink. The state of Louisiana passes a law to centralize the butchering industry, to create one corporation with a monopoly in the name of public health. The butchers who are shut out file suit. They say that the state has violated their right to earn a living, that the 14th Amendment protects their privileges and immunities as citizens, that this is what equal protection means. The case reaches the Supreme Court. Justice Samuel Miller writes the opinion. He is careful, cautious. He says that the 14th Amendment was written to protect the newly freed slaves, not to regulate ordinary state economic policy. He says that the Privileges and Immunities Clause refers only to a narrow set of federal rights, not to the broad protections the butchers are claiming. And as for equal protection, Miller barely discusses it. He says the clause is aimed at laws that discriminate by race, not at laws that regulate commerce. The butchers lose, and the 14th Amendment, just 5 years old, is already being limited. You are back on the platform now, in Louisiana, watching Homer Plessy board the train. He takes his seat in the whites-only car. He does this deliberately. He is part of a group called the Comité des Citoyens, a coalition of black and Creole activists in New Orleans. They have planned this. They have chosen Plessy because his skin is light. He is 7/8 white by ancestry, and they want to show the absurdity of the law, that race is a legal fiction, that separation is arbitrary. The conductor approaches. He asks Plessy if he is a colored man. Plessy says yes. The conductor tells him to move to the colored car. Plessy refuses. The conductor signals. A private detective, hired for this purpose, steps forward and arrests him. Plessy is charged with violating Louisiana's Separate Car Act, a law that requires railroads to provide separate accommodations for white and black passengers. The penalty is a $25 fine, but the case is not about $25. It is about whether a state may separate people by race and still claim to offer them equal protection. You are standing in the Supreme Court in Washington, 4 years later. The arguments have been made. Plessy's lawyers have said that separation itself is inequality, that a law dividing people by race violates the plain meaning of the 14th Amendment, that equal protection means the law must be colorblind. Justice Henry Billings Brown writes the majority opinion. He says that the 14th Amendment was meant to ensure legal equality, not social equality. That a state may separate the races as long as the facilities provided are equal. that the law does not stamp black passengers with a badge of inferiority unless they choose to see it that way. He writes, "If one race be inferior to the other socially, the Constitution of the United States cannot put them upon the same plane." You read that sentence and feel the weight of it. The court is saying that the Constitution does not require equality in fact, only in form. That separate can be equal. That the law may divide people and still claim to protect them. There is one dissent. Justice John Marshall Harlan, a former slaveholder from Kentucky, writes it. He says that the Constitution is colorblind, that it knows no superior or inferior race, that separation by law is a badge of servitude, and that the 14th Amendment forbids it. But he is alone. The doctrine is now settled, separate but equal, and it will stand for 58 years. You are standing in Topeka, Kansas, in 1951. A man named Oliver Brown is walking his daughter Linda to the bus stop. She is 7 years old. The bus will take her across town to the Monroe School, an all-black elementary school. There is another school 4 blocks from her house. It is called Sumner. It is for white children only. Oliver Brown tries to enroll Linda at Sumner. The principal refuses. Brown files suit, along with 12 other families. They say that segregated schools violate the Equal Protection Clause, that separation is inherently unequal, that black children in Topeka are being denied the same education as white children, not because the buildings are different, but because the law itself marks them as inferior. The case is combined with 4 others from across the country. It reaches the Supreme Court in 1952. You are standing in the courtroom now, listening to the arguments. Thurgood Marshall is speaking. He is calm, methodical. He presents evidence from psychologists showing that segregated schools harm black children, that they internalize the message that they are not worthy of learning alongside white children, that this is not a matter of facilities or funding, it is a matter of dignity. The justices ask questions. Some are sympathetic, others are wary. Chief Justice Fred Vinson is cautious about overturning Plessy. The court is divided, and then Vinson dies. President Eisenhower appoints Earl Warren as the new Chief Justice. Warren is a former governor of California. He is not a legal scholar, but he understands politics, and he understands people, and he knows that this case is not just a legal question, it is a moral one. Warren works behind the scenes to build a unanimous decision. He meets with justices one by one. He listens to their concerns. He drafts an opinion that is short, clear, and direct. On May 17, 1954, he reads it aloud. You stand in the courtroom and hear him say the words, "We conclude that in the field of public education, the doctrine of separate but equal has no place. Separate educational facilities are inherently unequal." The room is silent. Warren continues. He says that segregation generates a feeling of inferiority among black children that may affect their hearts and minds in a way unlikely ever to be undone. That the Equal Protection Clause does not allow a state to deny children an education simply because of their race. Plessy is overruled. The doctrine of separate but equal is dead. But the question remains, what does equal protection actually require? You are standing in a small house in Virginia, in the middle of the night in 1958. The door bursts open. Sheriff's deputies enter with flashlights. A man and a woman are asleep in bed. The deputies demand to see proof that they are married. The man points to a marriage certificate on the wall. The deputies arrest them anyway. The man's name is Richard Loving. The woman's name is Mildred. He is white, she is black, and under Virginia law, their marriage is a crime. The law is called the Racial Integrity Act. It was passed in 1924 to preserve the purity of the white race. It says that a white person and a colored person cannot marry. The penalty is up to 5 years in prison. The Lovings are sentenced to 1 year, suspended on the condition that they leave Virginia and not return together for 25 years. They move to Washington, D.C. They live there for 5 years, but Mildred misses her family. She writes a letter to the Attorney General of the United States, Robert Kennedy. He forwards it to the American Civil Liberties Union. The case goes to the Supreme Court. You are standing in the courtroom in 1967. The state of Virginia argues that the law does not violate equal protection because it applies equally to both races. A white person cannot marry a black person, and a black person cannot marry a white person. The burden, they say, is the same. The justices are not convinced. Chief Justice Warren writes the opinion. He says that the freedom to marry is a fundamental right, that a law restricting marriage based on race violates both due process and equal protection, that equal application of a discriminatory law does not make it constitutional. He writes, the fact that Virginia prohibits only interracial marriages involving white persons demonstrates that the racial classifications must stand on their own justification as measures designed to maintain white supremacy. The law is struck down. The Lovings go home. You are standing in Idaho, in a probate court. A boy has died. His parents, separated, both petition to be the administrator of his estate. The mother, Sally Reed, files first, but the probate judge appoints the father, Cecil Reed, instead. Why? Because Idaho law says that when two people are equally qualified, males must be preferred to females. Sally Reed challenges the law. She says it violates equal protection, that the state cannot prefer men simply because they are men. The case reaches the Supreme Court. Justice Warren Burger writes a short, unanimous opinion. He says that the law is arbitrary, that it bears no rational relationship to the state's interest in efficient probate administration, that giving a mandatory preference to one sex over the other is unconstitutional. This is the first time the Supreme Court has ever struck down a law for discriminating based on sex. Equal protection, it turns out, is not just about race. You are standing outside a medical school admissions office in California. A man named Alan Bakke has applied twice to the University of California Davis Medical School. He has been rejected both times. The school has a special admissions program that reserves 16 out of 100 seats for minority applicants. Bakke's test scores and grades are higher than some of the students admitted through the special program. He files suit. He says that he has been denied equal protection because of his race, that the university is discriminating against him because he is white. The case reaches the Supreme Court. There is no majority opinion. Justice Lewis Powell writes the controlling opinion. He says that racial quotas are unconstitutional, that the school cannot set aside a specific number of seats based on race alone, that this is not equal protection. But he also says that race may be considered as one factor among many in admissions decisions, that diversity is a compelling interest, that a university may seek to create a diverse student body as long as it does not use rigid numerical goals. 4 justices agree that quotas are unconstitutional. 4 others say that the program is legal. Powell is in the middle. Bakke is admitted to medical school, but the question is left open. When, if ever, may the government use race to achieve equality? You are standing in a hospital in Ohio in 2013. A man named James Obergefell is holding the hand of his partner, John Arthur. John is dying. They have been together for 20 years. They fly to Maryland, where same-sex marriage is legal, and marry on the tarmac. A medical plane is waiting. They return to Ohio. 3 months later, John dies. James wants to be listed as the surviving spouse on John's death certificate, but Ohio does not recognize their marriage. The state refuses to list James's name. He files suit. The case is combined with others from across the country. The question is whether states must recognize same-sex marriages and whether they must allow same-sex couples to marry. The oral arguments are tense. Some justices ask whether marriage has always been between a man and a woman, whether the definition can change, whether the Constitution requires it to. Justice Anthony Kennedy writes the majority opinion. He does not rely solely on equal protection. He also invokes due process. He says that the right to marry is fundamental and that it cannot be denied to same-sex couples. That equal protection and due process work together to protect liberty and dignity. He writes, "No union is more profound than marriage, for it embodies the highest ideals of love, fidelity, devotion, sacrifice, and family. In forming a marital union, two people become something greater than once they were." The decision is 5-4. Same-sex marriage becomes legal nationwide. You are standing in a modern courtroom now, trying to understand what equal protection means. It does not mean that all laws must treat everyone the same. States may charge different fees for fishing licenses based on residency. They may set different speed limits on different roads. They may require doctors to have licenses but not barbers. What it means is that the law cannot classify people in a way that is arbitrary, irrational, or based on prejudice. But how do courts decide what is arbitrary? They use tiers of scrutiny. Most laws are reviewed under rational basis. This means the law must be rationally related to a legitimate government interest. It is an easy standard to meet. Courts defer to legislatures. If there is any conceivable reason the law might be rational, it will be upheld. For instance, a state law says that optometrists cannot work in a store owned by a corporation. A group of optometrists challenges it. The Supreme Court says the law is rationally related to protecting independent optometrists from corporate pressure. The law stands. Laws that classify based on sex or legitimacy of birth are reviewed under intermediate scrutiny. This means the law must be substantially related to an important government interest. It is harder to meet. As an example, Mississippi University for Women refuses to admit men to its nursing school. A man challenges the policy. The Supreme Court says the state has not shown that excluding men is substantially related to an important interest. The policy is struck down. Laws that classify based on race, national origin, or that burden fundamental rights are reviewed under strict scrutiny. This means the law must be narrowly tailored to achieve a compelling government interest. It is very hard to meet. Let's consider. A city requires all laws to be published in English only, even though many residents speak other languages. A court applies strict scrutiny because the law affects access to government. The city must show a compelling reason. If it cannot, the law is struck down. But these standards are not mechanical. Justices disagree about when to apply them and what they mean. Consider affirmative action. Some say that any use of race in admissions is unconstitutional, that the 14th Amendment requires the government to be colorblind, that considering race, even to promote diversity, violates equal protection. Others say that the amendment was written to help Black Americans overcome centuries of oppression, that it allows, perhaps even requires, race-conscious remedies. that refusing to see race is refusing to see inequality. In 2023, the Supreme Court ruled that universities may no longer consider race as a factor in admissions. The decision was 6-3. Chief Justice Roberts wrote that eliminating racial discrimination means eliminating all of it. Justice Sonia Sotomayor dissented. She wrote that the decision cements a superficial rule of colorblindness as a constitutional principle in an endemically segregated society. The question remains unresolved. You are standing now in a quieter place. Not a courtroom, not a law library, just a room with a question. The question is, what does it mean for the law to protect people equally? Does it mean treating everyone the same, no matter their circumstances? Or does it mean treating people differently when their circumstances are different? Consider two students. One grows up in a wealthy suburb with excellent schools, private tutors, test prep, and a college counselor. The other grows up in a neighborhood where the school has no music program, no advanced classes, and teachers who are overwhelmed. Both apply to the same university. If the university treats them the same, judging only test scores and grades, is that equal protection? Or is it equality only in form, not in fact? Some had in the middle of this question, and you realize that equal protection does not have one answer. It has many, and the answer changes depending on who is asking and when. In 1896, the Supreme Court said that separation by race did not violate equal protection as long as the facilities were equal. In 1954, the court said that separation itself was inequality. In 1967, the court said the government could not ban interracial marriage. In 1971, the court said the government could not prefer men over women in probate. In 2015, the court said the government could not deny marriage to same-sex couples. In 2023, the court said universities could not consider race in admissions. Each case turned on the same 14 words. But the meaning of those words shifted with time, with context, with the composition of the court, and with the values of the society that interprets them. You are standing in a law school classroom now, late in the evening. The students have gone home. The casebooks are closed. You sit alone and think about what equal protection really is. It is not a rule, it is a principle. It is the idea that the government may not treat people as lesser because of who they are. That the law must have a reason for what it does, and that reason cannot be prejudice or fear or mere tradition. But principles do not enforce themselves. Equal protection exists only because people have fought for it. Homer Plessy, who sat in a train car and was arrested. Linda Brown, who walked past a white school every day. Mildred and Richard Loving, who were exiled for falling in love. James Obergefell, who wanted his husband's name on a death certificate. They brought cases, they argued, they appealed, and slowly, over decades, the meaning of equal protection expanded. But it is not finished expanding. There are still questions the courts have not answered. Whether the government may discriminate based on wealth or immigration status or disability. Whether algorithms that sort people by risk scores violate equal protection. Whether climate policies that harm certain communities more than others can be challenged on equal protection grounds. The doctrine is still being written. You are standing now in a place you have been before, a courtroom, quiet, empty. The judge's bench is polished. The witness stand is unoccupied. The jury box waits. You think about the weight of judgment, about what it means to decide whether a law is fair, whether it treats people equally, whether it divides them for a reason that matters or simply because it can. and you realize that equal protection is not a thing the Constitution gives you. It is a thing you must demand. It is the insistence that the law cannot make you lesser, that it cannot treat you as though you do not matter, that if the government is going to draw a line between people, it must be able to say why, and the why must be more than convenience, more than habit, more than fear. You close your eyes. You imagine the voices of everyone who has ever stood before a court and said, "I am a person. I am owed the same protection as anyone else." And you realize that those words, simple, plain, quiet, are the entire meaning of the 14th Amendment. Not a promise that has been kept, but a promise that is still being made. You leave the courtroom. The doors close softly behind you, and the question remains, as it always has, what does it mean to be equal under law? The answer is still unfolding.